Hello, and thank you for joining us. My name is Bailey Cordonier, and I am the president of the Northwestern student chapter of the Federalist Society. Thank you to the Environmental Law and Property Rights Practice Group for setting up this PG-15 study break. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. Our speaker today is Eric Grant, partner at Hicks Thomas. Before rejoining the firm, Mr. Grant was the federal government's top appellate lawyer for energy and environmental litigation as a Deputy Assistant Attorney General in the Environmental and Natural Resources Division of the U.S. Department of Justice. He has immense experience in the area of environmental law, handling numerous cases across all levels of courts.
Thank you, Bailey, for that introduction, and thank you to the Federalist Society for inviting me to do this study break. As Bailey mentioned, I'm doing it on behalf of the Environmental Law Practice Group, on whose executive committee I serve. Practice groups are a great way to get involved in the society and to meet other law students and lawyers who share your subject matter interests, and I commend them to you both now and after graduation. On to the topic at hand, climate change litigation for kids, the case of Juliana versus United States. I was told to avoid giving you a mere lecture, and so I am going to tell you a war story. Like all good war stories told by lawyers, I am the hero of the story, although perhaps the unsung hero. Our story begins in 2015 when a group of 20 or so kids brought a lawsuit in federal district court in Oregon. And if I can share my screen, you will see these beautiful children as they eventually appeared on the steps of the Supreme Court. The lawsuit asked the district court to recognize a previously unrecognized constitutional right, assertedly based in the Due Process Clause of the Fifth Amendment, to quote, a climate system capable of sustaining human life, unquote. That lawsuit further asked the court to enforce that new constitutional right by ordering the defendants, who consisted then of President Barack Obama and 8 cabinet departments and agencies, to do some wild and crazy stuff. I want to show you exactly what stuff, precisely because it is so wild and crazy. Whoops, there we go. I will let you read that slide. That snippet came from the district court's opinion and order denying the government's motion to dismiss in November of 2016. In that opinion,
so sorry, I don't believe your screen is being shared.
You don't. Okay, share screen. I am sorry about that. There we go. Do we have it shared now? Do we see the Kids Against Climate Change on the Supreme Court steps?
Yes, perfect.
Excellent. And then we'll go to hear what the plaintiffs asked the court to do, and take a look especially at that highlighted portion. So where was I? In that opinion, the district judge basically held, yes, Virginia, there is such a constitutional right, and yes, I can enforce that right by ordering the president and 8 cabinet departments to cease doing some things and start doing other things, all with this goal about atmospheric CO2. And this is where I entered the story. You may recall another wild and crazy thing that happened in November of 2016. And that thing led me in April of 2017 to begin serving as the political appointee in the Environment Division of the Justice Department, directly overseeing all of the federal government's energy and environment-related appellate litigation in all courts save the Supreme Court. And my #1 priority from day one was to kill Juliana versus United States. I'm going to stop that sharing for a second. The career lawyers in the Environment Division, that is the 450 or so lawyers who represent the government, regardless of which political party controls the executive branch, wholeheartedly agreed with that goal. And that agreement stemmed primarily from the fact that the district court ordered the case to go to trial, and not just any trial, a trial of 50 court days, or at least 10 full weeks. That is a monumental undertaking. Trust me, it will be a rare thing in your legal career if you were ever part of a trial of even half that length. And it was the consensus of all lawyers in the government that we did not want to participate in that trial. And we believed it was unfair to make us go to trial to determine a remedy for an asserted constitutional right before that right was recognized by an appellate court. And so we reiterated our request that the district court certify its ruling for interlocutory appeal. And I'm going to share again here. And we have there, I hope, the statute governing certification of interlocutory decisions. And note for future reference the highlighted phrase in the statute. The district court repeatedly refused, and so we filed a petition for writ of mandamus in the U.S. Court of Appeals for the Ninth Circuit. There it is. A mandamus petition is an extraordinary request for an appellate court to interfere in some way with an ongoing proceeding in a trial court. Even filing such a petition is rare, and having it granted is extraordinarily rare. It took basically a full year to brief that petition and to argue it, which is another rarity, and to receive a decision in the Court of Appeals. And that decision was petition denied. But we didn't take it lying down. Rather, we filed another mandamus petition asking the Ninth Circuit to stay proceedings in the trial court while we sought review in the U.S. Supreme Court. And there's our second petition. And we prevailed on our Justice Department colleagues who handled the government Supreme Court to seek a stay of proceedings in the trial court. There's the government's petition in the Supreme Court. Now, the Supreme Court, with a twist, as part of what has become known as the shadow docket, the going large. I guess I went away for a while. Am I back, Bailey?
Yes, you're back.
I guess sharing the screen isn't going to work very well, and I'm sorry about that. I was talking about going to the U.S. Supreme Court after the Ninth Circuit denied us relief, and the Supreme Court said no, but with a twist. You may recall, if the slide ever got up, the statutory criteria for certification included the requirement that the legal opinion present a substantial ground for difference of opinion. And the Supreme Court's order denying relief nonetheless observed that there was a substantial ground for difference of opinion about this issue, whether there was a constitutional right to 350 parts per million of CO2 in the atmosphere. And I think Supreme Court practitioners would get this message, but the district court and the Ninth Circuit did not. Rather, the district court denied the government's motion for judgment on the pleadings, refused to rule on the government's request to certify that decision for interlocutory appeal, affirmed the magistrate judge's granting of burdensome discovery against the government, and set a trial date for October 29th, 2018. So we filed another petition in the Ninth Circuit, which was denied, followed by a mandamus petition in the U.S. Supreme Court with a request for a stay of proceedings. The Supreme Court again said no, but again with a twist. This time it said no in a 3-page order that reads like a short opinion. And again, the court strongly hinted that the lower court should award the government relief from the impending trial and certify the issue for interlocutory appeal. The court explained that, quote, adequate relief may be available in the United States Court of Appeals for the Ninth Circuit, unquote. And the Supreme Court pointed out that the Ninth Circuit's basis for denying the government relief in the past rested on reasons that, quote, are to a large extent no longer pertinent, unquote. Hint, hint. We filed yet another mandamus petition in the Ninth Circuit asking it to take the Supreme Court's hint and act on it. At long last, the lower courts got the hint. The district court finally acted on the government's long pending motion to certify the denial of its motion for judgment on the pleadings, and lo and behold, the district court granted that motion, if in a manner that can only be called grudgingly. That required one more extraordinary filing in the Ninth Circuit, namely a petition for permission to appeal pursuant to the statute that I cited, and lo and behold, that was granted too, and the case moved to the Ninth Circuit, averting the scheduled 50-day trial. I won't bore you with the merits of the appeal. Suffice to say that the appeal turned on an issues of so-called Article 3 jurisdiction. And I had a great slide from my former Justice Department colleague and work friend, Corinne Snow, to show you, but I won't crash this again. So ultimately, the government won in the Ninth Circuit on the lack of redressability. As stated in the opinion reported at 947 F3rd 1159, the court framed the dispositive issue as whether an Article 3 court can provide the plaintiffs the redress they seek, an order requiring the government to develop a plan to phase out fossil fuel emissions and draw down excess atmospheric CO2. The Ninth Circuit, quote, reluctantly, unquote, concluded that such relief is beyond our constitutional power. I wish I could say that my brilliant performance at oral argument contributed to that victory, but alas, by the time of argument, I had a new boss and he took the argument for himself, as bosses are wont to do. And I wish I could say that all's well that ends well, but incredibly, even though the Ninth Circuit ended its opinion with express instructions to dismiss for lack of Article 3 standing, the case is still going on in the district court nearly 3 years later. The plaintiffs want to amend their complaint to seek only a declaration that the government is violating their constitutional rights. Incredibly, the district judge is refusing to implement the Ninth Circuit's clear mandate. I offer just a few lessons. Lesson 1, perseverance. The famous inventor Thomas Edison is said to have said that genius is 1% inspiration and 99% perspiration. Based on my more than 3 decades of law practice, and especially including my experience in the Juliana case, that aphorism holds true for litigation as well. In litigation, one might say success is 10% strategic thinking and 90% perseverance. Be the litigator who satisfies deadlines without asking for extensions. Be the litigator who reads all of the documents. Be the litigator who keeps fighting, always within the rules, of course, until you prevail, or sometimes until you learn finally that you won't. And lesson 2, your boss may steal your argument. This has happened twice in my career, and it is always a disappointment, but it happens to a lot of lawyers. Get ready for it. And with that, I guess I'm done with my opening, and Bailey, you may have some questions, and some of our audience may have some questions.
Thank you so much. A fascinating tale of war, definitely. I do have a few questions. When I look at this case, I see a lot of similarities to Massachusetts versus EPA in terms of a grand environmental idea that they want to implement, but that came out quite differently. So I was wondering if you could talk about the differences between those cases and why people aren't going through states like they did in Massachusetts v. EPA to have a better shot at standing in cases like this.
Yeah, that's a good question, Bailey. And in fact, kind of the current wave of climate change litigation is brought by states and municipalities around the country. We're kind of at the stage where the defendants, who are typically the fossil fuel companies like Chevron and Exxon and so forth, are trying to remove those cases, which are brought typically in state courts, trying to remove those cases to federal court. So far, they've been slightly successful in at least getting the Supreme Court to tell the courts of appeals that they have to consider the company's arguments for federal jurisdiction, but on the merits, when those arguments are considered, the companies are largely unsuccessful. And I think very recently, and I can't remember which circuit it's from, but the companies filed a cert petition asking the Supreme Court to resolve those issues. So yeah, states are involved again in climate change litigation.
So one of the first photos you showed before the screen sharing went haywire, hashtag YouthVGov is obviously a very powerful, PR campaign or some sort of wider messaging. Either in your experience or from what you've seen generally, is there something like that happening on the opposite side, or do they just focus on what's happening within the court?
On the opposite side, I guess I'm not.
Sorry, either the government trying to defend its actions,
or
in your experience as an environmental law in the private sector.
Yeah, having been on the government side, I would say the government's media strategy is usually not very good. And it's not that the lawyers aren't talented, or even the other people involved aren't talented. It's just that there are so many decision makers that it's hard to make a decision. One of the things that bedeviled us in the Juliana litigation was in the Trump administration was whether we would amend the answer that the Environment Division filed during the Obama administration. And we just had the gamut of opinions from let's amend the answer to deny everything, and to let's leave it alone, to let's make some tweaks, and ultimately the status quo of doing nothing prevailed because there were just too many decision makers to come to a consensus. And so I think that's kind of the problem with the government's media strategy, and so it's essentially non-existent.
Before I get to my next few questions, I want to remind our audience, we welcome your submissions for questions for the speaker. Please submit your questions via the Q&A feature or submit via chat, either one, and we'll get to those soon. Hopefully we'll have quite a few. So my next question is why children? This is climate litigation for kids. Many of the plaintiffs, are children. Was that a legal or tactical?
I think that was a media-driven strategy, and to give the plaintiffs and their lawyers credit, it worked. Those were extraordinarily photogenic children. Although by the time we got to the end, they weren't so young anymore. And as to some of the allegations of injury, they did have to do with being young and suffering from supposedly distinctive maladies of youth, allegedly caused by climate change. But yeah, I think mostly media driven, and it worked.
Interesting. So just going back a bit to how this all started, was this just an abstract suit based on a tort, or did they ask for a rule under the APA? What did they do to get some of this injury in the beginning, if that makes sense?
Yeah, it was basically kind of a jump in with both feet and ask the district court to declare a new constitutional right. And if you dive into this case, into the details, you'll see not only seeking a new constitutional right, but a radically new application of an old doctrine called the public trust doctrine. So it really was unconventional. we did argue at various times that the plaintiffs needed to proceed under the Administrative Procedure Act and needed to, as to a particular claim, needed to proceed in the Court of Appeals under the Natural Gas Act. But they self-consciously said, no, we don't. We're seeking to enforce a constitutional right under the Fifth Amendment, and we don't care about the APA.
So we do have an audience question. How do we prevent or deter people from asking for specific remedies from judges, like affirming a right for less than 300 parts per million, or asking for specific executive actions being taken? And how do we deter judges from treating these fantastical demands seriously?
Yeah, I don't have a grand solution for that. I think for the most part, the regular rules worked here. It did take that perseverance on the part of the team of lawyers of which I was the quarterback. All of us worked hard. We had many talented contributors. And it took, by my count, 4 mandamus petitions in the Ninth Circuit, a mandamus petition in the U.S. Supreme Court, 2 extraordinary stay applications in the Supreme Court, and other extraordinary filings. Now, I think the courts made us work a little too hard and tip the balance a little bit too much toward the plaintiffs. And I don't know if that was just a combination of a particular district judge and the Ninth Circuit as constituted at the time. So we faced some long odds, but I think the normal rules basically worked and can work in the future.
And just to give the audience a wider context, how common are cases like these? Did you see quite a few of them during your time in the government?
The short answer is no. If you, as a practitioner, file 1 mandamus petition in a U.S. Court of Appeals in your career, that's probably above average. It's just not things that you do. And the Ninth Circuit's opinion, 2018 opinion, denying mandamus goes through some of the statistics to show how rare that kind of relief is. And for us to have to file 4 in the Court of Appeals and 1 in the U.S. Supreme Court, yeah, that's crazy. That's not normal.
So in your speech, you mentioned sort of the fact that there was a change in presidency at one point during this litigation, and obviously now there's been another. What impact does that have on climate change litigation or any similar areas that may be politically salient in your experience?
Yeah, my experience was that the career lawyers who, as I mentioned, stay from administration to administration, had a pretty consistent attitude about this litigation. They were zealous in the defense of their client agencies and the distractions that litigation like this and discovery burdens and burdens of preparing for what would have been a 50 court day trial. They were consistent across all administrations in opposing things like this. Now, when it comes to things like the arguments by the fossil fuel companies in defense of the litigation brought against them by states, I think the Biden administration is going to be different from the Trump administration. That's almost certain. I don't know that the Solicitor General has yet weighed in on those things, but if she does, it'll almost certainly be against federal jurisdiction. And I think that the Trump administration was different in that regard.
So I know we have just a few minutes left, I want to switch gears a little bit and ask you a couple questions about the practice group itself. So this practice group is not only environmental law, but property rights as well. Uh, In your experience, do these overlap quite a bit? And broadly speaking, in what ways have you seen?
Well, there is some overlap. I would say at the ends of the spectrum, some of the lawyers don't understand what other or appreciate perhaps what people on the other end are doing. But it was interesting in my experience in the environment division. We not only did environmental law, but we defended the federal government against takings claims. And so for me personally, it was an overlap. And having been a part of the practice group for 20 years or more, I think it works reasonably well. There have been proposals to reorganize the boxes, but I think these present boxes work pretty well. And lawyers in both subsets are very talented and committed individuals.
So you've been part of the practice group for quite a while. How do you utilize the group in your everyday practice? Is it to bounce ideas off of people, resources, or is it just a place to meet like-minded people?
Yeah, I think the best use is again, as I said at the beginning, to be put in touch with people who share your subject matter expertise. And you may learn of a conference, you may learn of a case, you may learn of developments that you otherwise wouldn't have seen if you weren't part of a group like this. So it can be useful. And I don't know, Bailey, do we have some questions in the chat, or is that
Yes, so we have a couple here from Paul Piazza. What specific skills or experiences that you honed in your government service do you find are the most valuable in returning to private practice?
Well, I guess being involved in the extraordinary aspects of appellate practice. I don't know that I had ever done a mandamus petition or an injunction pending appeal, but something like that. Some extraordinary thing came across my desk at least once a week. And in part, that was just because I had an appellate case come across my desk one every business day for almost 4 years, so almost 800. And it was a fascinating experience to get the variety of quirky things that can go on in the U.S. Court of Appeals, and to work with some very talented people in responding to those issues.
And one last question before we conclude from Bob in the chat. What were some of your best memories working in the government? And maybe you just answered that, I don't know.
Yeah, I think that was, I guess, to put it one slightly different perspective, it was to work on things that showed up in the headlines for good or for ill. Some of the pipeline litigation, the Dakota Access Pipeline and the Keystone XL Pipeline, which had two very different fates, but over the course of 4 years, got to spend a lot of time on both of those, and one came out the right way, and the other on the first day of the next administration, all my work went down the drain. But good experiences nonetheless, working with good people.
All right. Well, we're coming on time. I want to be respectful of the students who have to get back to finals. But this has been fascinating. On behalf of the Federalist Society and everyone, thank you so much for taking the time to do this with us. For everyone in the audience, be sure to tune in next week, same time, same place, for Bureaucratic Police, the Power of Administrative Investigators with Boston College. Thank you so much.